Assalamualaikum to everyone and especially to Miss Siti Aja. So today my name is Alif Imran with two more, Siti Mastura and Mimi Farain. We three of us will present about our topic today relating to the case study. So we will present about the topic that we will choose. So it's about court case where we need to do a group assignment about the court case study. Thank you. In our content, there are 4 content that we put in our presentation. So firstly is introduction, second main content, third recommendation, and lastly conclusion.
Assalamualaikum warahmatullahi wabarakatuh to Miss Haja. My name is Mimi Farai Meti Saidi and my metric number is 2019-582425, and now I'm presenting my group assignment of case study for subject of industrial relation, HRM 659. So first of all, I would like to explain about this subject. In this subject, it explains a various of component of Malaysian industrial system, including the responsibility of government, employers, and trade union. Industrial relation, or also known as employment relation or labor relation, is the relationship between employees and employers. Industrial relation governed by the Industrial Relation Act 1967 with the purpose to regulate the relation between employees and employers. Besides, it provides a decision-making in the areas of work life based on the rules and regulation, including in terms of compensation, workers' rights, duties of employee and performance and disciplines. Meanwhile, employment law was established in order to provide a basic right for both employers and employees, especially in terms of wages and manual work. In addition, it is also stated the right of trade union for both employees and employers, including in terms of safety and health. In trade union, it explains the employer's right to take disciplinary action to their employees, and also the right of employee to join in trade union, trade dispute, collective bargaining, industrial action, and industrial court. Case facts. There are 4 parties involved in this case, which is the first one is National Union of Bank Employee, the second is Maybank Banking Berhad, Segamat, Branch Kuala Lumpur, the third one is Malayan Commercial Bank Association, and the last one is Industrial Court. National Union of Bank Employee, or NUBE, is an association which represents the employee, and Malayan Banking Berhad, or MBB, is employers, and Malayan Commercial Bank Association, or MCBA, is an association that represents the employers. The complainant, National Union of Bank Employee, lodged a complaint to the Malayan Banking Berhad regarding to the issue of non-payment bonus performance for 18 months and different payment bonus performance in Peninsula, Malaysia and Sarawak. In this case, Malayan Banking Berhad accused for non-compliance with the collective agreement under the Article 4. Initially, on 25 June 2009, NUBE returned to MBB called for a clarification of its procedure pertaining to the inconsistencies of bonus payment to the clerical or non-clerical employee staff in Peninsula Malaysia and Sarawak. And next, on 11 January 2011, NUBE had declared a trade dispute to MBB by request intervention from the Director General of Industrial Relations. It is the obligation of MBB to pay payment bonus performance as stated on agreement. And then, on April 2011, 7 members of NUBE raised a grievance to the MBB. However, this refused by the branch manager by saying that there is no necessity for doing a grievance. And then, MBB also claimed that the grievance contemplated by Article 4 of the collective agreement was office-level grievance, and therefore, the staff were precluded by Article 4 from invoking. They also say that the Article 4 did not provide the members with an avenue to make demands for terms and conditions of employment that they be paid 18-month bonus. Other than that, they also claim Large had already over the time limit provided in the Article 4 Sub 2A in the collective agreement, which need to resolve within the 7 days. And then, however, NUBE were not satisfied with the decision by the MBB, and this case had continuously with the intervention of Malayan Commercial Bank Association, which is MCBA. On 15 August 2011, a meeting of Standing Committee was held. In this case, MCBA claimed the submission that the alleged grievance of NUBE members will fail to meet the requirement, which is due to time frame under the Limitation Ordinance, Section 6 Sub A, which had been passed over 7 years. Therefore, the failure to resolve this issue through Standing Committee had encouraged NUBE to bring this issue to the Industrial Court. MCBA agreed this issue to be heard at the Industrial Court with the condition only one case to be heard from the 50 cases submitted before. As a result, the Industrial Court had made a result which is MBB need to comply with the provision of Article 4 Sub A, B and C.
Assalamualaikum Ms. Haja, my name is Siti Nur Mastura binti Hanif and my matric card number is 2019 707247. Now, I would like to explain about the main and sub-issue that occur under this case. Okay, so the main issue that occur under this case is whether the defendant, which is Berhad, need to comply to the agreement in Article 4 Sub 2 Sub B and Sub C of the collective agreement date 10 August 2010 and subjected to Section 56 Sub 1 of Industrial Relations Act 1967. This is because, based on the article, the defendant, which is Berhad, did not comply with the Article 4, Sub 2, Sub B and C that caused the National Union of Bank Employees, which is NUBE, was filed a complaint under Section 56, Subsection 1, whereby the Berhad did not comply with award or collective agreement. Okay, next, the sub-issue that made the NUBE want to claim the Berhad did not want to comply with a collective agreement is regarding to the non-payment bonus performance and time frame of complaint. Okay, firstly, the first reason why the National Union of Bank Employees, which is NUBE, make a complaint because Berhad give awarding performance bonus to the clerical and non-clerical staff in Sarawak only, and they did not pay that bonus performance to clerical and non-clerical staff in Peninsular Malaysia. Based on the case study, the National Union of Bank Employees state that there has been 18 months non-payments performance bonus from the Berhad to the clerical and non-clerical staff in Peninsular Malaysia. Okay, so regarding those case, 7 individual members of NUBE have a grievance and require Berhad to solve their problem within 7 days according to Article 4 of the collective agreement. This is because, based on Article 4 of the collective agreement, the Berhad need to settle the grievance of employee within 7 days. But if the issue still not have a solution, the Berhad needs to hold a meeting to settle the dispute as soon as possible. In addition, for this case, Berhad does not want to solve the grievance of their employee and they did not give a consideration to hold a meeting to solve the problem. So, this can be proven when the branch manager of Berhad said that it is not necessary to hold a grievance meeting because they said that the complaint come from office level. So, they can settle that problem because it is not their jurisdiction. But based on Article 4 under the collective agreement state that employee can file their agreement. Employee can file their grievance to the employer if there any breach of agreement of the employer. Okay, so according to the scope of collective agreement, any parties who involved under collective bargaining has a right to fight their right based on the terms and conditions that agree between the parties. This is because collective bargaining gives the worker the opportunity to participate in the formulations of their term and condition of employment to promote a good relationship between parties in the organization. Therefore, if one party failed to reach the agreement, this issue can be complained at industrial courts under Section 56 Sub 1 because the party did not comply with any award and collective agreement. Under Section 56 Sub 1, the National Union of Bank Employees has their right to make a complaint if there any party do not comply with any terms of the award and collective agreement which has been cognized by the court. So, National Union of Bank Employees (NUBE) has their right to file a complaint against Maybank Berhad to the industrial court because of they did not want to settle the dispute among them in a professional way. Secondly, the other issue between the National Union of Bank Employees and Maybank is time frame of the complaint. In this case, the Malayan Commercial Bank Association was represented on behalf of Maybank Berhad. Based on their submissions, the Malayan Commercial Bank Association said that the time frame that the National Unions of Bank Employees is backdate. Therefore, they cannot claim the unpaid bonus from the Maybank Berhad. This is because the complaint that the National Unions of Bank Employees makes is late. According to the Section 6, Subsection 1, under Limitation Act 1953, the National Union of Bank Employees cannot claim their performance bonus because the time that make a complaint is backdate. This is because in order to make any complaint, the time frame of the complaint must be 6 years from the date on the cause of action occur. Besides, the complaint that has been made by the NUBE is exceeding 10 years, which the date of the complaint is in 2010, while the issue occurs since 2000. This case can be related to the case of Nik Cheko v Public Bank Berhad. Was held that the earliest time the respondent can explain about a suit is after issuing the notice of demand April to 1968, within the 6 years from the case occurred. Therefore, since the suit was filed more than 6 years after the cause of action occurred, a suit was state bar based on Section 6 Subsection 1, Subsection A of the Limitation Act. So, the Cheko v Public Bank Berhad case is the same as NUBE and Maybank Berhad. The action of contract, such as breach of contract, can be claimed shall not after the expiration of 6 years from the issue occur. So, this matter on the complaint, the National Union of Bank Employees will be ignored because they claim that they made a big deal.
From discussion, in fact, we compare to issue with the legal issue. The grievance procedure Article 4 was intended to cover the complaint of individual employees at the level of office with regard to matters affecting the branch. Usually, limitation require the grievance to be filed within time period starting with the occurrence or termination of the act, forming the basis of the grievance at the time when the party became aware of the act. Is set off for the employee during the which time it must be observed that the employee is obligated to leave his concern The grievance should be initiated within 7 days, and it is view of the court that this must be 7 days from the date on which they knew or he knew the incident which form basis of his or her grievance.
According to the above issue, the judge required Maybank Berhad to comply with the provision of Article 4, Sub A, Sub B and Sub C. This is because if the Maybank Berhad did not comply with the Article 4, they can be convicted under Section 56, Subsection 1 because of non-compliance with an awards or collective agreements and serve the grievance of their worker. The reason why the court or judge make this decision is that it will promote harmony relationship in industry between employer and employee. With all the regard, the court decided to close this case according to Section 30, Sub 5, where the courts will take an action according to the equity, good conscience and substantial merits of the case without regard to legal form and technicalities. This is because as an employer, they should be fair and justice with all the employees, whether in Peninsular Malaysia and Sarawak. In addition, both parties must comply with the terms and conditions in the collective agreement. As an employer in Maybank Berhad, they should negotiate properly and give consideration according to the issue that appear of their worker with the unions to avoid this problem become worse. This is because if the employer consider with this problem, it can be settled in a proper way without interference with industrial court. Last but not least, the employees under the National Unions of Bank Employee should take their action earlier to avoid the action that was accrued according to Section 6, Subsection 1 under Limitation Act 1953. This is because Section 6, Subsection 1 state that any problem or unfairness or injustice in the employment contract or collective agreement can be claimed only in 6 years from the issue occur. So, as an employee, they should be alert and follow the law that appear under Limitation Act 1953 to make a claim regarding to their problem.
Okay, moving on to the recommendation. After we had analyzed this case study, we are agree with the final decision made by the Industrial Court against Maybank Berhad, where this company need to comply with the Article 4, Sub A, B and C under the collective agreement. This is because it is fair and justice due to the legal regulation under Section 56 Sub 1 in Industrial Relation Act 1967. However, we would like to point out several recommendations for this case. First of all, both parties should aware and comply with the regulation. It means that employers and employees need to comply with the regulation that provided by the industrial relation, especially regarding to the procedure, in order to avoid trade dispute and grievance. Based on our study, the procedure that used are not comply with the procedure to make a grievance. In fact, in grievance handling procedure, employer could provide a feedback to their employees, such as through survey or questionnaire pertaining to the employee satisfaction in the workplace. This is because through this method, the employer can analyze the problem that occur in their organization or between employers and employees. And through this, it also can prevent the issue from become a big issue. For instance, Maybank Berhad can distribute their questionnaire upon their employees in order to know their problem or their opinion regarding to the management. And this can help them to improve their procedure and regulation in their company. Next, improve human resources responsibility. When a grievance was raised by NUBE to the MBB, branch manager had become intermediaries between employer and employees. Here, human resources manager should play their roles and responsibility as an intermediary in the company in order to resolve this problem or issue. For example, human resources can collaborate with the branch manager to solve the issue that arise in their organization. This is due to their responsibility to handle the employee relation with employer. Therefore, when human resources manager play their roles in organization, this issue could solve without the intervention from the trade union and industrial court. And this can be proven when the branch manager had refused the grievance from the employee without intervention of human resources management, and then this issue had become a big issue. In addition, human resources manager could provide an advice and information regarding to the Industrial Relations Act, especially on a grievance procedure to the employer and also employee, so that both parties will understand the regulation that they need to follow in order to solve their problem in the organization. For example, in case of employee, this can be proven when the employee failed to obey the time frame under the Section 6 Sub 1 on Limitation Act to claim their unpaid bonus performance to the Maybank Berhad. Meanwhile, the employer failed to comply with Article 4 in the collective agreement. Hence, every parties, including employers, employees and union, should concern about the legal regulation under the Industrial Relations Act and Employment Act, including the right and benefit for both parties in order to avoid from any dissatisfaction or problem occur in the organization. So that through having information or knowledge about legal regulation, both parties can build a harmony relationship between them in the workplace. And also, it will improve their organization performance in terms of their quality and output in the workplace.
As our conclusion, the judge require Maybank Berhad to comply with the provision of Article 4 and complaint made by employee or MBB. The court decide to close this case according to Section 30, Subsection 5, where the court will take action according to equity and substantial merit of the case. Maybank Berhad need to comply with the agreement Article 4 A, B and C. This is because the issue where the state has been 80-month non-payment performance bonus from the Maybank to the Peninsula Malaysia worker. This is because the bonus were given to the staff is for Sarawak only. We also provide recommendation for this issue, where the rule provide the structure necessary for an engaging and productive. Keep it simple and easy to follow. It can be general to cover different situation or very specific to student. I think that's from us. Thank you for listening. Thank you.